Hello, my name is Dr. K.P. Asha Mukundan and I am a faculty working with Tata Institute of Social Sciences, School of Social Work, Center for Criminology and Justice. Today I am going to talk about the module on probation. Here in this module, the main objective is to understand the system of probation, to understand the role of probation officers and to understand the concept of probation within the JJ system. Let me begin with the introduction. The Indian criminal justice system is based more on the ideology of penology rather than reformation. The general understanding of people on penal provisions are known to be incarceration or prison, institutional or fine, that is non-institutional. Not much is known on other non-institutional reformative provisions like compensation, release on admonition, probation, imposition of fines or community service. One of the reasons for the same probably could be because they are less used to terms such as this. Terms such as probation, parole and furlough came to be known in the public domain probably when the Bollywood actor Mr. Sanjay Dutt tried to avail of the same and it got reported in the leading newspapers. The actor however did not get benefit of probation, which would have meant that he would not have to go to the prison and could have continued to stay with his family under the supervision of a probation officer. However, he made best use of the option of parole and furlough once in prison. These are concepts which we will be talking about, especially the probation. According to the United Nations Department of Social Affairs, the release of offenders on probation is a treatment prescribed by the court for persons convicted of offences against the law. During the period of probation, the probationer lives in the community and regulates his own life under conditions imposed by the court or under constituted authority, namely the probation officer who also supervises the probationer. The suspension of sentence under the probation services the dual purpose of deterrence and reformation. It provides necessary help and guidance to the probationer in the process of rehabilitation. The United Nations recommends the adoption and extension of the probation system by all the countries as a major instrument of policy in the field of prevention of crime and the treatment of the offenders. This module looks into the working of probation and the probation officer within the juvenile justice system, which functions differently from the working of the larger adult criminal justice system. The term probation is derived from the Latin word probare. This word means to test or to prove. Probato means test on approval. The criminal justice system, being a purely legal system, looks at probation as a system of dealing with offenders by placing them under the supervision of a probation officer, while the juvenile justice system, being a socio-legal system, interprets it in the context of a process of period in which a person's fitness as for work or membership in a crucial group is tested. The ultimate aim, however, being rehabilitation and reintegration of the individual into society. However, to understand probation in the juvenile justice system, it is important to understand the same in the criminal justice system. So, let us begin with looking at the history of the probation. John Augustus from Boston, Massachusetts is considered to be the father of probation. In 1841, John Augustus attended a police court to bail out a common drunkard who is recorded as the first probationer. Augustus was convinced that abusers of alcohol could be rehabilitated through understanding, kindness and sustained moral persuasion rather than through conviction and jail sentences. The offender was ordered to appear in court 3 weeks later for sentencing. However, 3 weeks later, the court was surprised to see a very sober man with a more polished appearance and a demeanor accompanied by Augustus. This success got Augustus to work as a volunteer probation officer for 18 long years. The offenders helped by Augustus were not limited to alcohol abuse, but ranged of different offences. John Augustus did not randomly ask for probation, but made an assessment of the person who would benefit from supervision and would be a candidate who would likely prove to be a successful subject for probation. The offender's character, age and the people, places and things apt to influence him or her were all considered. He also maintained detailed notes of the process used in each case. He was the first to apply the term probation to this method. Thus, Augustus set the rules criteria for intake, supervision and the process. To begin with, let us look at the Probation of Offenders Act of 1958. Some of the salient features of the same are: 1. The role of probation and probation officer in the adult criminal justice system or CJS begins after the offender is found guilty. B. Section 4 of the Probation of Offenders Act, hereby called POA, provides power to the court to release certain offenders on probation of good conduct. The offender is released on entering a bond on probation of good conduct with or without supervision and on payment by the offender the compensation and cost to the victim if so ordered. The courts being empowered to vary the conditions of the bond and to sentence and impose a fine if he failed to observe the conditions of the bond. Third, Section 6 of the same Act lays special onus on the judge to give reasons as to why probation was not awarded for a person below 21 years of age. The court has to call for a report from the probation officer before deciding to not grant probation. Thus, in other words, it becomes mandatory for the judiciary to explore the possibility of probation before passing an order. The person released on probation does not suffer a qualification attached to a conviction under any other law. Fourth, duties of probation officer mentioned in the Probation of Offenders Act involves: 1. To inquire in accordance with any direction of a court into the circumstances or home surroundings of any person accused of an offence with a view to assist the court in determining the most suitable method of dealing with him and submit reports to the court on regular basis. The second role of the probation officer is to supervise. Probationers and other persons placed under the supervision and where necessary endeavour to find them suitable employment. The third role is to advise and assist offenders in the payment of compensation or cost ordered by the court. The fourth role is to advise and assist in such cases and in such manner as may be prescribed to persons who have been relaxed under section 4. Fifth role is to perform such other duties as may be prescribed. So, the role of the probation officer is vast. In short, the above mentioned duties fulfill the role of supervision and rehabilitation. Now, let us look at the procedures for granting probation in the larger adult criminal justice system. First, the judge calls for the PO report or the probation officer report. Mandatory to call report for below 21 years of age if offence does not warranty life sentence or death. The PO does a home visit talks to the family, neighbors, colleagues, offenders and submits confidential report along with the recommendation for or against the probation for offender. The person who is found guilty, that is those about 21 years and offence calls for fine of punishment less than 7 years, or those below 21 years and offence does not warrant life sentence or death. These are the people for whom the judge has to call for a probation report. Then the probationer is kept under the supervision of a probation officer. If probation is not granted, then the judge has to cite reasons for the same. The judge may or may not accept the PO's recommendation. It is all left to the discretion of the probation officer. Now we look into the probation in the juvenile justice system. The role of the probation officer in the juvenile justice system begins when the child first enters the system, unlike the adult CJS, when the role of a probation begins at the end of the trial where the adult is found guilty. Section 248 of the JJ Act defines probation officer as an officer appointed by the state government as probation officer under the POA Act 1958 or the legal cum probation officer appointed by the state government under the district child protection unit as mentioned earlier. The JJ Act is a socio-legal act. Probation is rehabilitative order developed as a non-custodial alternative. It can be passed by a judicial magistrate first class and can be passed only with respect to a child in conflict with law. The duties of the probation officer is extended also to a child in need of care and protection or CNCP. The question that would arise in the minds of many are, how can the role of the probation officer extend to victimized population when probation is mandated only to the offending population? This is stipulated in section 14B of the Probation of Offenders Act, which states, supervise probationers and other persons placed under the supervision. The other persons can be interpreted in the Juvenile Justice Act to include CNCPs. Section 14C of the Probation of Offenders Act also states to perform such duties as may be prescribed. This gives the flexibility for the PO to function roles as stated by the CWC, who are empowered magistrates, and JJB, who assign them tasks under the JJ system. Probation is a rehabilitative order developed as a non-custodial alternative to imprisonment. It can be passed by a judicial magistrate first class. This gives the flexibility to the PO to function roles as stated by the CWC and the JJB, who assign them tasks under the JJ system. Now I am going to talk about the role of a probation officer in the criminal justice system and the juvenile justice system. Let us look at some of the differences and similarity between the two. The role of a probation officer in an adult criminal justice system is limited with respect to those who are found guilty and given probation order. However, the probation in juvenile justice system is applicable not only to those who are guilty, but also to the children in need of care and protection. The role of PO begins at the end of the trial in the criminal justice system, whereas the role of PO begins when the child first enters the system in the juvenile justice system. The next difference is the role of PO is when in the criminal justice system is only when there is a probation order, whereas the role of a probation officer in the juvenile justice system is not limited to probation orders only. In the adult criminal justice system, there is no provision for offenders to be kept under the supervision of a probation officer while on bail, whereas in a juvenile justice system, the children are kept under supervision of a PO at the time of bail as well. This is mentioned in section 12 of the Juvenile Justice Act. Under the CJS or the criminal justice system, all those given the benefit of probation will not suffer disqualification, whereas in the probation in the juvenile justice system, All those found to have committed an offence and dealt with under the provisions of the JJ Act itself will not suffer disqualification. The last point that one talks about is that an adult can only be placed for probation with a government appointed probation officer in a criminal justice system. In the juvenile justice system, the child in conflict with law can be placed on probation under the care of a probation officer, parent, guardian, fit person or fit facility. We just looked into the table which talks about the differences between the probation system in the criminal justice system and the juvenile justice system. Now, let us look at the role of a probation officer with respect to the CCLs or the children in conflict with law. The role of a probation officer begins at the time of apprehension. Section 13(1)(2) of the JJ Act states that when a child in conflict with law is apprehended at the police station, the same should be informed to the parents and PO, that is the probation officer. The role of the police and PO starts simultaneously. The police does the investigation of the offence, while the PO prepares the social investigation report, also known as the SIR. Then the next role is production before the Juvenile Justice Board. When the CCL is first produced before the JJB, he or she is either released on bail or kept in the observation home. Section 12(1) of the JJ Act provides for release of CCL on bail with or without supervision or with or without surety, or placed him under the supervision of a probation officer or under the care of any fit person. Generally, bail under supervision is conditional in nature. This is because the process of rehabilitation of the CCL begins at the time he or she enters the system. For example, it may not be appropriate to keep a CCL having an addiction problem or any kind of mental illness or psychiatric issues in a children's home. In such cases, it would be best to release the child in conflict with law out on bail under the supervision of a probation officer under the condition of treating the child in conflict with law in a de-addiction center or a mental health hospital, depending on the nature of problem. Similarly, if a CCL is in school or is a school going child, then admitting him or her in school may affect future prospects of the CCL. The CCL should in such conditions be released on bail under the supervision of PO with the condition that the CCL would have to regularly attend school. The other duties of the PO with respect to the child in conflict with law are: 1. To prepare SIRs. That is, the social investigation of the PO is very crucial to the hearing of the case, as the JJ system lay emphasis on the circumstances in which the offence has been done rather than the offence itself. SIR contains information regarding the antecedents and family background of the child and other material circumstances likely to be of assistance to the board for making the inquiry. POs can give their options or recommendations for rehabilitation of the CCL, which may or may not be accepted by the JJB, because the discretion lay in the hands of the JJB. The other role of the probation officer is to mentor the CCL. The PO is expected to regularly interact with the CCLs and prepare individual care plans to facilitate rehabilitation irrespective of CCLs being on bail or housed in the observation home. The PO is expected to coordinate with various experts to develop the individual care plan, like the psychologist, educators, counselors and many other people, to come together and work out a care plan for the child. Section 19(1) of the JJ Act makes it mandatory for the probation officer to prepare individual care plan and also do a follow up of cases of CCLs above 16 years of age and those who have committed a serious offence. The next role of the PO involves during police investigation. If the CCL is in the observation home, the PO, the police can interact with the CCL in the presence of the PO or any other social worker or caretaking staff. This is to ensure that fair means are being used by the police during investigation. The role of the PO again continues in cases of heinous offence. Section 15 of the JJ Act states provision for preliminary assessment of a CCL above 16 years of age and has committed a very serious heinous offence in order to ascertain his mental and physical capacity to commit such offence and his ability to understand the consequences of the offences and the circumstances in which he allegedly committed the offence. The section further states that this assessment has to be done by a psychologist or a psychosocial worker or other experts. In the absence of the psychologist and psychosocial workers, the Juvenile Justice Board is seen taking the assistance of a probation officer as other experts for the purpose of assessment. This is a very crucial role as the person who prepares this report has to objectively, free from bias and understand the larger ideology of rehabilitation within the juvenile justice system while preparing this assessment report. This report would determine if the case of a child in conflict with law would be heard at the Juvenile Justice Board or the Children's Court. The implications being that if the case is heard in the Juvenile Justice Board, there shall be no disqualification attached to the case on the child in conflict with law. But if the case is heard in the Children's Court, then the child in conflict with law would hold a criminal record for a lifetime and would not be able to apply for a government job which mandates the candidate to get a character certificate from the police. This has been a big hurdle in the process of rehabilitation. Besides this, Section 20L of the JJ Act provides for the probation officer to do an assessment or evaluation and follow up of a CCL or a child in conflict with law who has attained the age of 21 and yet to complete the term of stay in the observation home or the special home or the place of safety as to find out if the person has undergone reformative changes and can be contributing member of the society. The probation officer has to coordinate with other relevant experts and prepare a report. This report is crucial as it would determine if the CCL would then be sent to prison or be released given the good conduct displayed. The crucial role of the probation officer is supervision. This involves supervision of CCLs during bail after the final order is passed with respect to section 18B of the Juvenile Justice Act stipulating group counselling, under section 18C which is about providing for community service orders, under section E that is probation of good conduct with the PO. None of these final orders passed exceed the period of 3 years. For example, if a child in conflict with law is given a community service order to work in a school library, then the probation officer must supervise if the child in conflict with law is regularly going to the library, doing work well and using time constructively and not just being exploited by school authorities to do mundane activities like cleaning the premise, wiping the boards, etc. The other role of a probation officer is to network with other stakeholders and agency. For this purpose, for the purpose of NGOs or civil society organizations, inquiry for vacancies in other organizations either for residential, vocational, educational, de-addiction services, etc. There is also an importance to network with other agencies for follow-up of cases. The escort is to be provided by the police for the transfer of the children in conflict with law to other districts or states. This networking has to be done by the PO. The PO also has to network with other agencies for job placements. The PO also has to network with CWCs of other states and other districts for the rehabilitation of the children. The role of probation in CNCP cases. As mentioned earlier, the order of probation cannot be passed for CNCP children. However, the roles and duties of a PO is also extended to children in need of care and protection. Some of these duties are: the PO is generally the PO is generally the first point of contact for children brought into the children's home. 2. The PO can produce a CNCP before a CWC. 3. Prepare an SIR and submit the same before the Child Welfare Committee as per section 33 of the Juvenile Justice Act 2015. 4. Prepare individual care plans for children in the juvenile justice system. 5. Prepare progress reports of the child on periodic basis and submit the same to the CWC. 6. To reintegrate or reunite children back with families. 7. Coordinate the transfer of children to different institutions either in the same district or different state or even different country. For this purpose, the PO has to network with the concerned agencies like JJB, POs, CWC and other embassies and maybe the embassy. What are the benefits of probation and supervision under the care of probation officer? One of the options in the JJ system is that if the child has been found to have committed an offence, then they can be sent to a special home for a maximum term of 3 years. This process is better understood as custody. Here, the child in conflict with law is isolated from the community and lives with other offenders serving the term there. Imprisonment decreases his capacity to readjust to the normal society after the release, and association with professional delinquents often has undesired effects. By releasing the child under probation or under the supervision of a probation officer, the connect with the community is maintained. The normal life of the child is not disrupted. For example, if the child does go to school, then he or she can continue to go to the same school. Psychologically too, living within an institutional premise with other children who may or may not have a propensity with offending can be damaging, especially in India. The component of counselling and vocational training within institutional setting has not developed much. An unbiased social investigation report and sincere individual care plan can go a long way in the rehabilitation of a child, be it a child in need of care and protection or a child in conflict with law. Conditional bail under supervision is seen as a powerful tool for rehabilitation. This is because the process of rehabilitation begins at the time the child in conflict with law enters the system. Psychologically, the CCL is also wary about residing in the observation home and would do anything to stay away from being institutionalized. The CCL is well aware that breaking of conditions would require the consequence of bail order being revoked and CCL being sent in custody. This acts as a deterrent and gets the CCL to abide by the conditions set in the bail. Abiding by the conditions of the bail is a step towards rehabilitation. Conditions for bail could include attending de-addiction program, school vocational training, counselling, etc. Institutionalizing a child has a labeling effect. According to the labeling theory, a stigmatizing label once applied is likely to cause further deviance or create deviance. People tend to conform to the label even when they do not set out that way. Child under the supervision of the PO would continue to live with the community and be assisted into becoming self-sufficient and controlled and self-confident and productive citizens. Supervision under PO serves the needs of the community as well, because at times the parents, guardians or members in the community find it difficult or express inability to control the CCL or the child. Under the supervision of the PO, the child is aware of the consequences of revoking of supervision order leading to custody. Given this deterrent factor, the child conducts himself as per the expectation of the community. Finally, there are studies in the adult system to show that it is not only psychologically but also economically viable to place a child out on supervision over in the process of institutionalization. Let us look at some of the challenges of effective functioning of the probation system. In the majority of states in India, the ratio of probation officer to the number of children in the JJ system is not proportionate. In many states, there is just one PO for every district. The ratio between the PO and children at any point of time is 1:50 or more. As a result, the PO is not always able to do justice to the role. Understanding the limitation, the JJ Act is framed in a manner to state that if the PO is not available, then the child welfare officer or other agencies can substitute the role, although the final choice of preference should be the PO. In order to meet up with the challenges of the numbers, the government has also made provisions to increase the number of POs to work in the system through the Integrated Child Protection Scheme, better known as ICPS. However, lack of coordination between ICPS and POs, contractual appointments of POs under ICPS and funding status has created hitches in the effective working of the system. The children assigned to the PO are from different geographical areas, and visiting them is a very time consuming activity for a PO. In rural areas, the PO has to travel more than 50 kilometers to visit a child. Thus, only one supervision visit can be done in a day. In rural areas, the transportation system is not so efficient. Hence, the PO has to try and coordinate the visit as per transportation timings. The PO generally does not have a vehicle at his or her disposal. Also, hiring a vehicle is not always reimbursed by the government. This leaves the PO with limited options for travel. Given the above mentioned challenges, it becomes difficult for the PO to maintain deadlines for submission of reports to the Juvenile Justice Board. Given the said challenges, the probation officer ends up talking to the child, either a CNCP or a CCI or CCL on the phone, and then prepares the SIR report. In district places, there are few organizations that work or function on this issue. The JJB has to rely on the PO for SIR, especially for CCLs. Given these known challenges, judiciary too have begun to lose faith in PO's reports, further demoralizing those working efficiently. Too many expectations from the PO, but lack of proper training to improve their skills have also affected their performance. The next factor is also the appointment of POs on contractual basis. Summarizing this entire module, within the juvenile justice system, probation continues to be a judicial order that can be passed only with respect to children in conflict with law. However, given that the Juvenile Justice Act is a socio-legal act, the meaning of probation is expanded to mean the social understanding of a process or period which a person fitness as to work or the membership in a society or group is restored. Given the role of POs within the JJ system, it is not limited to supervision and probation alone, but expanded to include supervision and rehabilitating victims as well as offenders, and this has a wide scope. The PO is expected to possess skills of counseling, psychology, communication, law. The work of the PO in the field-based job, which involves interaction with individuals and coordinating with various stakeholders to meet the ultimate goal of supervision and rehabilitation. It is not an administrative job. Given the role to be played, many states have stipulated that the PO should have a minimum qualification of Masters in Social Work. The PO has a huge responsibility to safeguard the rights of the children, draw individual care plans and execute them through mentoring and supervision to enable rehabilitation of the children. The number of probation orders have been on a decline, however, given the lack of availability of probation officer. Hence, the success of probation is entirely in the hands of the state government and the resources it allots to the programs. Resources are needed to employ trained probation officers. Effective functioning of probation requires intercoordination, especially between the judiciary and the Women and Child Development Department, the Social Welfare Department. To conclude, probation is an effective correctional tool and an affirmation in the belief that human beings can change with a little support and guidance. It should be given its due importance. Not much about probation in the Indian context is available online. However, we have put together a set of references which are attached herewith with this module. There is a lot of information, however, on the issue of probation in the international context, and there are a number of research studies also done on this subject. Do browse the net for further information. Thank you.